Please count numbers again.
3
Plus chairperson of 3 boards by rotation.
Yeah, that'd be 4 actually.
What?
Yes, 1. Your lordship is right.
8 altogether.
8. Yeah. Yes, your lordship is right. Because it'll be 1 Sunni board, Shia board, and the. That's it. That's right. Now kindly come, Mullahs, the board, that is section 14. So according to us, 9 is violative and 14 is violative. 14 is the membership of the board.
Yes.
Now it says it will have a chairperson. Board shall consist of not more than 11 members to be nominated by the state government. Nominated again. A chairperson, 1 member of parliament from the state. The case may be National Capital Territory. 1 member of the state legislature. Following members belonging to Muslim community, namely 1 mutawalli, 1 eminent scholar, 2 or more elected members of the municipalities or panchayats, provided that in case there is no Muslim member available from any of the categories, then 1 to 3 additional members from category 3 may be nominated. So that makes it 3 plus 2, 5 plus 1, 6, and 1, 7. And then 2 persons who have professional experience, maybe non-Muslims. Joint Secretary to Government of India, 1 member of the Bar Council, provided that 2 members of the board appointed under C shall be women. Provided further that 2 of the total members of the board appointed under this section, excluding ex officio, shall be non-Muslims. It's a complete takeover, Maharaj. It's a complete takeover through nomination. Now, Maharaj, if your lordship sees the 1995 Act, and I just presently give that to your lordships, the 1995 Act had all Muslims.
And a disqualification. Section 16 is disqualifies non.
That was, Maharaj, kindly see the council provision. I just point out the provision, Maharaj. Council provision was section 9 of the 1995 Act, all Muslims. Your lordship may just take it, it's all Muslims. And the board provision is section 14 of the 1995 Act, which is also all Muslim.
Next point.
And section 16 is a disqualification provision. For all
And from amongst Muslims, then there's a disqualification provision also.
that means non-Muslims are disqualified.
That's correct. That's correct.
Yes.
Now, Maharaj, the next section, Maharaj, is Chief Executive. No, let's leave that out.
Chief Executive Officer earlier had to be a Muslim.
All officers have to be Muslims earlier, including the Chief Executive Officer. I know that. Now it's not a Muslim. Now kindly come to registration.
Yes.
On and from the commencement of the Waqf Amendment Act, Section 36, Maharaj.
Yes.
1A, Maharaj. 36, 1 capital A. On and from the commencement of the Waqf Amendment Act, no waqf shall be created without execution of a waqf deed.
Wrong.
I'm not saying anything wrong, I'm just indicating, Maharaj. Waqf, kindly see, Maharaj, you can create a waqf by user. You don't have to have a deed. If it is my property, Maharaj, as your lordship knows, if it is my property, Maharaj, I can create a waqf. In the sense, I can allow somebody to say, have a shelter home there. I don't have to register it. It's my property, but supposing, forget about whether I'm the Muslim faith or not. Supposing my own property, I want somebody else to use it in the manner that I like. Who can interfere in that? As long as it's my property.
That's fine. Then
Why should I have to register?
there's no difficulty in that. You can register the work also because it will help you also have maintain a register of work.
No, that's another matter. But waqf by user is abolished now.
Will that not be beneficial? The question of work by user, you have an issue, we'll ask others.
But I'm just saying, waqf by user is now abolished. It's an essential part of Muslim law and Muslim faith. And it's recognized by your lordships in paragraph 1134 of the Ram Janambhoomi judgment. The lordship just note that. Para 1134. Which says precisely that.
There is nothing wrong if you permit somebody to use. If you want to dedicate it,
Then you can.
right, dedicating it to the Almighty. That is the concept.
That's right.
All that the section says is to avoid uncertainty, so that there is no, claim or a bogus claim, that you have a deed and portalize it.
I'm really not so much on that. Lordship is right. I'm just saying.
It will be perhaps beneficial.
Yes.
In a way, it will be beneficial.
Wait,
Prevent any dispute.
let's move on, Maharaj. Kindly come to
Why
7.
there is a dispute? Really speaking, until there is registration becomes a means.
There's a big problem there. I tell your lordship, they'll ask us now, and I'll show those provisions to your lordships. They ask us if there's a Waqf created 300 years ago, who created the Waqf? Give us information as to how it was created.
No, which provision?
Produce the deed if you can. So, Mother, they want all that information. And many of these properties were created hundreds of years ago. How will anybody ever prove it? And then, Mother, what happens is, and I just give you a historical background, which we'll argue when the main case is being argued. When the British came over here, Mother, what they did was all these properties, which were Waqf properties, what they did in the revenue record, they said Governor General. Now, on the basis of those revenue records, Mother, they say, if it's DDA, they say it is my property. And then, Mother, the collector will decide. So these are very serious issues that ultimately will have to be decided by a lordship. But prima facie, this is a matter because this will arise from all over the country. In every state, this will arise, which is why your lordship should take it over and hear and finally decide the matter. But let's kindly see 7A. Capital 36 7A.
Yes.
Where the collector in its report mentions that the property wholly or in part is in dispute or is a government property, or is a government property, the Waqf in relation to such property, such of the property shall not be registered unless the dispute is decided by a competent court, which could take 20 years.
The status quo as of now will maintain.
They are not saying that, Mullah.
The state, no.
Not under 3C, Mullah. Your lordship, I read that.
3C, there's a contradiction emerging between this and 3C, like us the other side. There's a contradiction emerging.
That's right.
And how will they interpolate 3C with 7A to 36 will be an issue.
Mullah, any entity, any person, if he claims ownership to property, has
Because
to go
that
through
says anything which is government property, then 3C applies.
Yes. So how do you decide whether it's government property or not? Not
Here it says, as far as government property is concerned, it has to be decided by a competent court.
That's the point.
If the decision is that of the collector.
That can't be, Mullah. It's a judge in his own cause. And Mullah, that's not a judicial process.
So argue that last.
Mullah, that's not a judicial process anyway, Mullah. Collector's process is not a judicial process.
Collector's decision is amenable to the tribunal.
No.
It's not amenable.
No, not that the section says so.
Section specifically says.
And or means also dispute. Kindly see, or is in dispute, which means they are not sure that this is their property. So nobody can deal with it, Mullah, till such time as it is decided. So it's no longer be a Waqf.
Next point, Mr.
So that's 7A, Mullah. Now kindly, then
Subsection 10.
Subsection
10 is the no suit, etc.
Yeah, no civil court will have jurisdiction. That's right. Then the
Which
tribunal.
one is that?
Well, that's subsection
10 of 36.
10. No suit of this section, Mullah. No suit, appeal, or legal proceeding for the enforcement of any right on behalf of any Waqf which have not been registered in accordance with the provision shall be instituted or commenced or first.
Limitation period.
Well, that's the other very serious issue. Previously, under the 1995 Act, there's no limitation. I'll tell you, Lordship, why.
Limitation can be always imposed by the government.
No, I'm on.
Like before 1995, we had the limitation.
Under the 95 Act, there was no limitation. I'll tell you the reason why. Because many of these Waqf properties were encroached upon. And therefore, Mullah, in the context
we can't really say that if you impose a period of limitation, it will be wrong, it will be unconstitutional.
No, because
what Limitation Act has its advantages.
I'm not on that, Mullah. I think the point I'm making is somewhat different. And the point is, Mullah, that at that time, if within 2 years we did not file a suit, I can't file a suit now. Therefore, Mullah, if the Waqf is created, say, in the 1930s.
There was no limitation period, that means you can always file a suit.
But now it says it has to, after
Yes.
2 years.
If your work property is not registered, then you have to file a suit within 6 months and 6 months plus.
No, but these properties are not registered. These are Waqfs by users, many of them. So how will I file a suit?
So we'll ask them about.
So therefore, that's the other.
We have understood. We have understood.
That's the other issue, Mullah. Yes, and they will claim adverse possession and encroachers will be legitimized. Encroachers will be legitimized in this process. And Mullah, kindly see now 1A. That's another important page number 51, Mullah.
1A or what?
1A of section 61, penalties. Sorry, it's fine. May I read that, Mullah?
Yes.
It says, if a mutawalli fails to deliver possession of any Waqf property if ordered by the board or tribunal, carry out the directions of the collector of the board, do any other act which he is lawfully required to do by or under this act, provide a statement of accounts under 46, upload the details of Waqf, he shall be punishable with imprisonment for a term which may extend to 6 months and also with a fine which shall not be less than 20,000.
That's in case of violation. There are so many acts. Which
No, just
Anyway,
go to jail, Maharaj. 3B, Maharaj, kindly see.
Since 90s, it was
3.3.
that's all, Mr. Sip.
No, Maharaj, just one other thing. Then kindly see 85.
85.
Yes.
Yes.
No suit or other legal proceeding shall lie in any civil court, revenue court, or any other authority in respect of any dispute, question, or other matter relating to any Waqf property or other matter which is required by or under this act to be determined by a tribunal.
This
So that
is a new one or
No, it was there. It was there earlier also. But there was a tribunal. The difference is that the nature of the act has been changed. Originally, everything had to be decided by the tribunal. Here they have introduced 3C, which the tribunal.
that's a.
Why not, Chief Justice? I have not forfeited my.
No, you have not forfeited. You're right.
Just to respond to one question that fell from your attentions. The basis of our constitutional attack is that a Waqf is essential and integral to Islam. That was the basis of our attack. And religion, and particularly charity, is an essential and integral part of Islam. The original test essential was in 54. This other aspects, my lord, Mr. Sibal, I adopt that argument, both about the change in the nature of Waqf, the change in the composition and loss of control. Earlier, even the chief executive officer had to be Muslim, no longer. And lastly, my lord, many of these provisions are arbitrary and contrary to Article 40. That is the summation of our argument. I'm very grateful.
I just want to say this. Points have been covered, the same points. Waqf by user deletion is very serious because the statistic is that 4 out of 8 lakhs, 4 lakh out of 8 lakhs perhaps are Waqf by user. So by one stroke of pen,
I didn't want to interrupt you with this. There's an issue. You see, when we were in Delhi High Court, we were told Delhi High Court itself is built on a Waqf land.
it's all right. It's all right.
Yes.
It's all right. So
We
that's
were
the name.
also told that Oberoi Hotel is built on a Waqf land.
Well,
There are villages which are declared.
Mr. Mehta, please. We are also told Parliament is Waqf land. That doesn't mean.
I'm sorry.
I'm sorry, Manoj.
Well, we are told
No,
Parliament
we
is
are-
also
we are
Waqf
not
land.
saying.
These
but
are imageries
don't-
created.
Just one minute. Don't misunderstand us that we are not saying that all work by users are wrongly registered, but at the same time, there's an issue and concern.
Absolutely, yes. Absolutely, yes. But what you are talking about is not individual abuse. You're not throwing the baby out with the bathwater. You are considering a per se legal abolition of the concept. Now, there's 2 issues arise here. Issue number 1. Waqf by user, is it a novel concept created? Is it something new? Your lordships in para 1118, I think it's 1134, it's para 1118 of Ayodhya's judgment, have traced that this is a very old lineage concept. Very old. Number 2 question arises legally. Have you removed the basis of the judgment? Also from Prithvi Cotton Mills through Madan Mohan Pathak, you have to do something to remove the basis. This act says that
understood that.
it deletes. No, boss, 2RI is deleted. Just see the old 2RI. 2RI today, your lordship, in the book is a blank. In the footnote is given the original 2RI. Now that you delete. By deletion, can you remove the basis of a judgment? The judgment was not based on a Waqf by user record. It's based on was ancient material. So that's point number 2. Point number 3, the practicality. 4 out of 8 lakh Waqfs are supposed to be Waqfs by individually. If I go and claim Parliament to be a Waqf, your lordship will not accept it. That I can understand. But you don't say the concept is bad. That's point 1. Point 2 is that there are 2 bodies. One is the collector, and one is this fellow called the designated officer. These 2 are the worst examples of judges in their own cause because of a series of provisions. Lordship will note that in this book, my learned friend has pointed out many of them. If you read them together, They are completely judges in their own cause, starting with 3 IIIDA. Just note that one. The collector is defined very, very broadly. Just see that definition. 3 IIIDA. Collector is not a mere collector as a lordship thinks, fellows. Everybody, land revenue collector, deputy commissioner, or not any officer below the rank of deputy collector. Then please add to it, fellows, these other provisions which say designated officers for other things, fellows. Till they decide, this shall not be treated as Waqf property.
That's it.
Thirdly, they will decide.
Mr. Sipal is already flagged.
Yes. Then, fellows, the third thing is, the third issue is, fellows, this is therefore there is a subordination. Whereas those provisions, my learned friend may have given you also the chart. Those provisions are very important. They are, fellows, just give me half a second. Sections of the Karnataka Hindu Religious Institutions Act, Dharmika Parishad Act, Religious Endowments Act, AP Charitable Act, and Sikh Gurdwara. The sections are there.
Dr. Singh,
Yes.
you already. That's all, Mr.
No, that's 1 minute more. 1 minute more.
For admission stage, this is something.
No, I'm not going to repeat, brother. I'm trying to, the problem is, well, trying to sift through that, which I don't have to repeat. There is, well, a reason why we are saying that this word contrivance is intended to make the person visit the officer for lifelong. Apart from the fact that I have to prove I'm an adherent to Islam. That one part has been argued.
5 years.
It's a cumulative condition. I've done Islam for 5 years. I go and show my faith to somebody. Thereafter, there is an additional cumulative condition of contrivance. Now, this is a delightfully vague word. It will mean I will continue going to the office and I'll be under your control
Dr. Singh,
for life.
it already argued.
For life.
So take away something.
Well, can I answer the first question? Can I answer the first question? There are 3 reasons why this should not even be considered remotely for going to the High Court. Just 3 reasons very quickly. 1, it has all India ramifications. Your lordships would never say, Malus,
But
that
then
there should be High Court judgments of multiplicity
Dr.
and
Singh,
diversity.
Except that argument, then a lot of matters where
No.
legislations are
No
challenged.
matter will come, Malus.
Always
This,
on
no,
internet.
kindly see. Would my lords countenance multiplicity of High Court judgments? Diverse High Court judgments?
We can direct
The
one
same-
High Court. We can direct
The
one.
same thing will happen, Malus. Your lordship will, Malus, today, number 1, this is the
But
most.
we have the
all India.
benefit then of the High Court judgment.
So let me give you all the 3 reasons. Number 1, Malus, your lordships, there is no absolute bar in 32. There is a discretionary
we are
bar.
not saying there's
3
bar.
conditions. 3
We are not
conditions.
saying there's a bar.
3 conditions. The first condition is Article 32. What is more, Malus, Part 3 than Article 26, read with Article 25 directly. Secondly, your lordship will have, Malus, all over the country, or even your lordship consolidates. What will be the point, Malus, of spending this time, and ultimately it has to reach the Supreme Court. So therefore, Malus, today, this is not that kind of a case where your lordship sends us to the High Court, Malus.
Okay.
And Malus, there is also an issue that your lordships, Malus, should lay down the law definitely on this one. I end by one thing.
Fine.
No, I'm saying only one thing.
Okay,
Some of these-
now 2 more.
No, 1 minute.
against on this slide.
1 minute.
A quick constitutional
One
point.
minute.
One second, Mr.
1 minute more only. Malus.
2 sentences only.
I am saying this, if Allahabad also meant the same, I'm sure. Some of these pernicious provisions, they have come into effect immediately. We are seeking a stay for the reason, your lordship has said in 3 judgments, Health for Millions, then Malus Jayashri and Rakesh Vaishnav. The only argument is a new act. Your lordship doesn't stay the act. There's not a question of staying the act.
We'll
When
come
the
to that
provisions are,
argument. We'll come to that part little later.
no, only one sentence, Malus. When there is a status quo continuing from 1923,
Dr. Singhvi, why are you arguing that?
the first act came in 1913.
But I have a slightly different take on things. So I'm in 13.2, the Association for Protection of Civil Rights. Just give me a moment. No, I just want to point out one thing which is very, very important. Article 26, apart from 25, Article 26, let's please just see Article 26 for a moment. Mr. Sibal showed it to your lordship, but I want to just stress one thing. Because I'm deviating a little bit from this essential religious practices or essential religious features argument. I don't think it's necessary at all, as far as the Waqf Act is concerned, to show that it is a part of the essential religious practice of Islam. Please see 26. Freedom to manage religious affairs, subject to public order, morality and health. Every religious denomination or any section thereof shall have the right, A, to establish and maintain institutions for religious and charitable purposes. Please note the distinction drawn by the framers of the Constitution. Religious and charitable purposes. Now, charitable purposes do not have to be to answer the test of essential religious features. There can be charitable purposes which have to do with a person who believes in Islam,
Understood.
but does not have to answer. Now, contrast and to manage its own affairs in matters of religion, etc., etc. Now in Shirur Mat, your lordship said there will be certain secular aspects where the state can intervene.
So you're saying just read D also.
No. So and D,
Just read D.
to administer such property in accordance with law. Yes. So a law which
The law can interfere.
uh,
This accepts that law administration will be in terms of the law.
no.
Will be framed.
Lordship is right. Preface.
Understood.
No. There's just one thing. Preface with subject to public order, morality, and health. Those are the only three. Now, please contrast this with 25. 25 says.
Another provision.
Plus 25 says, subject to public order, morality and health, and to the other provisions of this part. All persons are equally entitled, etc., etc. This is why, my lords, 14, 19, 21, etc., etc. The other provisions of this part came in, for instance, in Reverend Stanislaus, where your lordship were considering the Freedom of Religion Act in Orissa and Madhya Pradesh. 26 draws a complete departure from 25. This is now your lordships have held lords in Sayadna and reiterated that even while referring Sayadna recently, your lordships have held in the Dargah committee, your lordships have held in Sirur Mat. These are all constitution bench judgments. And my lords, in the state of Rajasthan versus Sajanlal, Panjabat, etc., series of judgments, your lordships have held that 26 bars state intervention except on provisions, except for public order, morality, and health.
That's what.
Now, therefore, please,
my lords.
and just one last point. It's a slight repetition. What I'm saying about just one thing on 3C, that's very, very crucial. Because the moment a dispute is raised, it's not.
Correct, we have understood that.
It ceases to be a waqf. I just want to put it in a context. Suppose there's a waqf by user for 300 years. Let's say it's a graveyard. Let's say it's a mosque. The moment somebody says, no, this is government land, you just have to say it. Then for the next 50 years, designated officer, tribunal, High Court, Supreme Court, it ceases to be a waqf. So that's very, very important in that context.
Yes,
There's a reason in constitutional history why 26B exists, to manage its own affairs in matters of religion. Your lordship is from Amritsar. Your lordship may recollect that the Golden Temple in Amritsar had non-Sikh control. It required a whole Akali movement to regain control of their own gurdwaras. So that is why the clue is to manage its own affairs. So own means necessarily an exclusion of somebody who is not your own. And that is the principle which has consistently been followed from Shirur Mat down.
I will make one submission. I won't repeat.
Can
Can I just take a cue from what my learner from Mr. Hegde said? I come from Kashmir.
Microphone.
Lord, I come from Kashmir. I am a Kashmiri Pandit. Correct? There are temples over there. If tomorrow Muslims were to say because they are in majority, they are going to manage my temples as it is my temples are gone, would that be acceptable to the other side? Please juxtapose it, this proposition with the acts that have been shown. And I made something for your lordship's convenience. No, this is not a submission.
Lord, I'll make one submission.
Lord, one more thing. Can I just complete one more thing? Your lordship was saying whether the decision of the collector. Your lordship was saying whether the decision of the collector is final. Please see section 40 of the old act.
Yes.
Would my lord just see it may help?
Yes.
You know, at the foot of the page, at page 38, these decisions where there was a dispute with regard to whether a property is, does my Lord Justice Vishwanathan have?
Yes.
Page 38.
Motion since deleted now.
It is, but it gives a perspective, my lord. It used to go to the board, and if there was a dispute, it would go to the tribunal further. For correct.
Now it does go.
3C says the collector decides, he is high and mighty.
To the tribunal,
That's all, I think that's the other side.
Lord, only one submission. Only one submission. Lord, kindly see, Lord,
You are
article.
paying for,
I will not repeat it, Lord.
no, you are paying for.
Lord, 103. Item number 103.
Pardon.
Lord, we are appearing for a DMK party as well as Lord, Member of Parliament, Mr. Raja. Lord, your lordship would kindly see, Lord, Article 26C. Lord, originally Article 31, Lord, where the property was there as a fundamental right, that was removed and, Lord, taken to Article 300A. But this 26C, Lord, remains to be there. So therefore, my lord, when can they tinker with the properties, my lord, of the religious, my lord, is subject to the public order, morality and health. Therefore, my lord, now this entire, my lord, amendment, my lord, they are attempting, my lord, they want, my lord, a probation period of 5 years, my lord, to certify that a person, my lord, is a Muslim. My lord, 3R, if your lordship sees, my lord.
That's been already argued, please.
Yes. So therefore, my lord, my submission is against fundamental rights.
Lordship, without,
That's all, please.
just in terms of additional sections that we are asking for stay off, just 2 or 3
We
more
have not
sections.
argued, we have not argued on state, we are not doing that.
So, Lordship, may I?
That's all, please.
Malad, I appear on item 63.
That's all, please. Nobody else.
Malad,
Please, no more. That's it. We have to draw curtains somewhere. At the admission stage, nobody has the right. All right.
41A may be read of the amending act.
Okay.
41A said, my lord, that the survey has to be done within 1 year's time. My lord, that was introduced, my lord, that was inserted in 2013.
Okay, yes. Yes, please.
In most survey, all the states are on record. There's a
Okay, that's all, please. Yes, please.
Malad, item 63, can I?
Sorry, no more.
Malad,
No, I'll have it put the curtain.
But Malad, just give me 1 minute.
Not required. We've heard you. We've heard the broad parameters on which you are, and in fact, the point which you have raised.
Can I just state something in 60 seconds, Malad, if your lordship allows? Because I had prepared a short note, but I take it that your lordship doesn't want me to hand that over. I won't hand that. Just 2 points. Firstly, on 3R, there are 3 facets. One is, my lords, that you change the definition. Everyone has said, my lords, that the original definition included Waqf by user. Now, Waqf by user has been omitted under the new definition. And Waqf by user, my lords, is a practice which is essential or fundamental to Islam itself.
We have understood.
And it can be trained.
Mr. MD, you're repeating.
Yes,
we have understood.
Very well. Then point number 2, my lords. Can I go to the next point?
Yes.
If your lordship allows. Point number 2 is this, my lords. The expression, my lords, if your lordship
we were
not
hearing
inclined,
you.
because I don't want to just stretch it further.
No, we are hearing you.
Very
It's not difficult.
So point number 2 is, my lord, the expression used in, my learned friend made the point, I just want to develop it a little more. The expression used is, my lords, practicing Islam for a period of 5 years. Now, if this is an essential religious practice and it is protected by Article 25 to 26, it has the effect of suspending fundamental rights for a period of 5 years. So point number 3, just 1 more minute. Just 1 more minute, please. One more aspect. You use the expression that you have to prove that you have been practicing Islam for a period of 5 years. Now, are you going to tell me that, Mr. Ahmadi, you don't offer prayers for 5 times a day?
That's it this way.
No, so therefore there is
elaborate that argument.
No, therefore there is an aspect of vagueness. How will you determine that? Will you tell a Muslim?
That's what Mr. MD.
Will you prohibit him from dedicating a property?
That's all.
Lordship, I'll just point out
Just 2 more points.
No, Mr. MD, that's
Just, I'm not
Mr.
repeating
MD, We
anything.
have heard you. I guess you have the most important points you've already had.
Lordship, I'll
Just 2 more points.
No more, Mr. MD.
I won't repeat.
3 provisions from
I'm not repeating anything, Malad.
That's all, Mr. MD. I don't want to keep on repeating.
Lordship, I'll just highlight 2 or 3 provisions which have not been pointed out to my lords. My lord, the proviso to section 2, which says that any trust, even if the objects are similar to a waqf, if it's established as a trust, will be outside the purview of the Act, notwithstanding any judgment to the contrary. Lordship, this amounts to overruling the judgment in Sheikh Yusufbhai Chawala. A judgment of the Supreme Court.
One minute. They can always change the language of the statute because the trust also has certain benefits. You can't say that one minute, please. Trust also has certain benefits. It's not that trust is deprived of all the benefits.
It's a question of regulation, Lordship. And this is just an overruling
What
of
by the special law? Sections of the CPC apply. They take
One submission in 30 seconds.
Lordship section, again, Lordship, I'm not done. I'll just take a minute. Lordship section 104, which earlier allowed non-Muslims to also register. So all of the Lordship are blatant violation of 300A of the Constitution, which is the right to property, saying that you can't alienate property, saying that you can't box property to the exclusion of heirs. Lordship mentioned Hindu Succession Act, and Lordship, Hindu Succession Act was a codification. It was not a question of imposing a law top-down contrary to personal laws. Here, saying that you can't box property contrary.
One submission in 10 seconds before
by the history of our 1956 Act, You know what happened?
Plus one submission in 10 seconds before your lordships call upon the other side. Just one submission in 10 seconds. Plus your lordships, insofar as collector in 3C is concerned, it's directly in violation of the principle in Roger Matthew and Madras Bar Association. Plus it's directly in the teeth of those judgments.
Yes, Mr. Mehta.
One
I'll just not, because
So, Mr. Mehta, now we want you to answer.
can I have 10
And
minutes?
then I'll have 3-4 questions to ask you.
Yes, but all your lordship's questions and the contentions will possibly, my lord, get answered, my lord, in what I'm going to submit. But at the outset, two things. Your lordships are dealing with a legislation, my lord, which has not just, my lord, came as a legislation. No, there was a constitution of a joint parliamentary committee. It, my lord, it held 38 sittings. It visited, my lord, all major cities, my lord, held consultation from 13th July to 7 November 23. My lord, examined 92.28 lakh memorandums, which are, my lord, considered, and, my lord, a bulky report is prepared. Thereafter, matter goes before both the houses of parliament, and your lordships, lords, are aware, detailed and, my lord, elaborate debates are, lord, made. Now, kindly come to the act. Lord, kindly have a look at the act. Some of the facts, some of the provisions, my lord, the other side missed, my lord, I believe must be by inadvertence. But please have a look at, my lord, the definition clause first. Please have a look at, my lord. My lord, if your lordships can take up, my lord, this chart, Lord, it would be relevant because, yes, Lord, please have a look at Lord, Waqf by usual. One of the most contentious issue, my lord, Waqf by usual. Lord, first of all, my lord, let me make one position very, very clear, and your lordships may kindly consider
So
my.
are you now saying Waqf by user, even if it has been established by judges for particular case, but or it is established otherwise, there is no dispute about Waqf by user. That now today stands void.
No, my lord, therefore I am saying, my lord, what was presented is not the correct statutory scheme. My lord, first of all, my lord, and examine my arguments based on this. My lord, I'll give two examples, my lord, not examples, my lord, in the case of Waqf. But I am a Hindu. I create a trust. My trust deed would say that all trustees would be Hindu. I would be, my lord, the settler of the trust. The trust deed would be the trust. And someone who will regulate the trust administrative secular activities would be the charity commissioner. My lord. Am I clear? It can be a public trust or a private trust. Here, in case of a Muslim, but Waqf necessarily under the Islamic law means dedication to Allah, Almighty Allah, for a particular charitable purpose is not accepted by the Islamic law. There has to be a Waqif. Waqif means the person who settles the trust. It's in parlance of Lord, which example I gave, settler of the trust. There has to be Waqif. Waqif would say that it would be governed by committee or an individual called Mutawwali, who all can be Muslims.
Correct. That's what Waqf by user is concerned. Right from.
I'm not on Waqf by user. Kindly
have understood that.
If your lordships can allow me.
We know only on Waqf by user.
If your lordships can, kindly bear with me. So far as Waqf is concerned, if it is governed as per the Waqif or as per the Waqf deed or as per anything by Muslims, this law does not come into the picture. What is Waqf board? Waqf board is the charity commissioner for Waqf. First, my lord, please bear, my lord, the distinction between Waqf board, Waqf council, and Waqf itself in mind. No act, my lord, this amendment touches the Waqf itself. And Waqf means the trust.
Please, sir. Out of this. So don't give the trust example. Nearest example will be the Charitable Endowments Act. The Hindu Religious Charitable Endowments Act. The states have enacted that.
Under somebody's supervision.
How is that administered? They are pointing out provisions that whenever it comes to Hindu religious charitable endowment, Hindu community which is administering it.
No, my lords. I don't wish to give examples. It will not be appropriate to give examples. I do not wish to, but take it from me. My lord, Hindu religious endowments, my lord, created by trust or by any other method, my lord, are governed by the whatever method is, but ultimate, my lord, the statutory supervision, control, coordination is by a body which may consisting of Hindus, may not be consisting of Hindus. That is why 25 and 26. Pardon?
Give us an example.
Let's not. No, let me.
TTD board doesn't have non-Hindus.
Yes. Bombay Public Trust Acts.
That's right. Trust is how trust is different. Trust is different because public trust.
There were several misstatements. No murmur from this thing. Let us maintain, my lord, a decorum. We are not arguing a religious thing. We are doing a legal thing. Howsoever.
Mr. Mehta does
Let's come to the proviso.
Mr. Mehta, let us be clear. As far as religious endowments of Hindus is concerned, normally it's the Hindus alone.
Ignore that part. Kindly come to the proviso. Kindly come to the proviso at page 6, my lord, of my compilation, of my, my lord, chart.
Yes.
Provided that the existing Waqf by user properties registered, please mark, registered on or before the commencement of the Waqf Amendment Act 2025 as Waqf by user will remain as Waqf properties. If they are registered, it will remain. Somebody says that why we did not register, and I'll come to that, my lord, what is the logic, and I'll satisfy your lordships. Except that I'll say that, Mr. Josefa, except that properties wholly or in part is in dispute. My lord, there is a civil dispute going on between either a private party and Waqf.
Why will it not remain a Waqf property? Let the Supreme Court decide that dispute.
It would.
Or if it's a government is raising a dispute, let it decide that. Now what is it?
My lord, if the lordship allow me to complete.
Just 1 minute, please. This is the second part of the argument.
The difficulty is when the petitioner starts without pointing out the contours, the respondent, my lord, doesn't get to assist the court, my lord. That's
we have understood. We are pointing out the last part of it. First part we have.
I'll tell your lordship, my lord, why? Right from 1923, the first Waqf Act came in 1923. Registration of Waqf is mandatory. Statutorily, mandatorily required. You cannot have an unregistered trust, a Waqf, even Waqf by user cannot be unregistered, which was followed by the Waqf Act of 1954. 1954 also, it is mandatory to have your Waqf by user or any other Waqf registered. That was followed by the Waqf Act of 1995, the present Act, my lord, where also the Waqf Act, the registration of Waqf is not only compulsory, the Mutawali, which Mr. Sibal pointed out that I'll go to jail. He is going to jail since 1995. If he is not registering his trust and not bringing it within the purview of the regulatory mechanism, there is a penalty provision of imprisonment since 1995. In 2013, my lord, the Parliament amended the Waqf Act, which I have pointed out. There also the Waqf registration is mandatory.
Mr. Tushar Mehta, just tell us one.
Yes.
Waqf by user, if accepted prior to the 2025 Act, it's now touched. 1 minute, please. Is it now declared to be void or non-existent?
No,
please take us. Be careful about your statement. Waqf by user, if already established and registered, say 1 minute, please. If already established, will it be declared in terms of the 2025 amendment now as void, or it will continue to subsist?
If registered, no. No.
36.
Yes, well, that is the exception.
1 minute. But then there's a catch here.
See, yeah, my lords are right. Subject
there are two catches. There are two catches here.
Yes.
One, it says, is in dispute.
For a court.
Where is it mentioned?
It is not.
That's not stated. Is in dispute means, 1 minute, please. Now, it doesn't say is in dispute. What do you mean by the term is in dispute? It doesn't say it's before the court or is otherwise in dispute.
Correct, my lord.
Number two, the issue is with regard to government property.
Correct, my lord.
Now, the fact of the matter is, before the Britishers came, we did not have any registration.
25 is British.
We did not have any registration act, the Transfer Property Act. Now, the Waqfs say many of the masjids, etc., may have been constructed now in 14th, 15th, 16th centuries, 17th centuries.
They could have been registered after.
But to accept, to require them to produce a registered sale deed will be an impossibility.
But I am not registered for both.
Today, it will be impossibility.
Lord, my lords, possibly where I'm not clear. Registration with the registering authority.
No, I'm
under
aware of
Waqf
that.
Act.
I'm now aware of that. But therefore, in
Not
most of the cases, say in case of Jama Masjid Delhi,
Yes.
the Waqf will be worked by user because the masjid was
Then
treated as.
nobody prevented them from not going and getting it registered.
So,
In fact, it was mandatory.
Yes, current Chief Justice is putting on. No, one minute. See, some of your provisions are saluted.
Yes.
Some of them require clarification.
Yes.
What the learned Chief Justice is putting to you.
Yes, Manoj.
A simple case where a Waqf user, somebody after the act goes and seeks registration, you register, no problem. What if 3C is invoked and a stake is made by the government that it is government property?
Please.
Just answer keeping one thing in. You have the Land Encroachments Act. Every state has land encroachment.
Yes, Manoj.
Disputes have arisen where the government says this is Parambok land or this is the government land. A bona fide dispute of title is raised. This court says whenever there is a bona fide issue, it is relegated to civil court, collector or will not assume power.
They can still go to the tribunal, my lord. Let me complete. my lord.
That is the answer you have referred.
What is being shown, my lord, is something, my lord, except my lord.
3C, if you see.
Now kindly come to 3C. Kindly come to 3C and my lord, read, my lord, the way the government has read and the parliament has read. Not, my lord, I would not sensationalize. No person shall create a Waqf unless, my lord, page 3C would be page
Capitals.
Page 8, my lord, I'm sorry. Any government property identified or declared as Waqf property, identified means it is being known as a Waqf, but not that government will now identify, Mr. Sibal said, or declared as Waqf property before or after commencement of this act shall not be deemed to be a Waqf property. There are judgments to the effect that the government as a trustee of the government land, Lord, can regulate it. Pause it, Lord, don't, Lord, let us proceed. If any question, they're very charged. If any question arises as to whether any such property is a government property, the state government may, by notification, designate an officer above the rank of collector, hereinafter referred to as the designated officer, who shall conduct an inquiry as per law and determine whether such property is a government property or not, and submit his report. Kindly pause here for a minute why this provision came. Well, Lord, nobody can dispute that the government property cannot be anything other than the government property. Suppose somebody is claiming to be having a Waqf on the government property, for example, Madhya Pradesh High Court.
No, but this provision has to be read, this section 1. First, you say any property identified or declared as Waqf property shall not be deemed to be a Waqf property. So you undo any further identification and declaration that a property is a Waqf property.
That is
So, and therefore, you undo that.
I am arguing as a law, and it's a lot of.
Don't worry on that side. You answer us.
I used to anyway.
Our answer should be 36(7) capital.
Exactly. I'm coming to that, my lord. Allow me to go, my lord, the way I'm wanting your lordships to look at that. At 83, my lord, 83, there is a provision. But kindly see, my lord, why this provision came. My lord, when it was an agreed position that if it's on the government land, then there has to be an adjudication about the land being government land or otherwise for revenue purposes, not for the purpose of title. The argument before the JPC was that collector is the revenue officer, he himself will be a judge in his own cause. Therefore, my lord, a suggestion was made by the JPC that the person who adjudicates under 30C2 should be a person above the collector. Now, what the collector does, what is the result of his exercise under 33C2? Please have a look at, my lord. 3. In case the designated of...
Proviso.
I'll just read the proviso.
It
Provided
means there is a moment the collector starts investigation.
Correct.
Is that fair?
Right. I'll have to...
Is that fair? Because he's still not decided whether it's government land or not, or it's work for not, what it is deemed not to be work.
Your Lordship, allow me to answer. But suppose there is a shop, there is a temple, there is a Waqf property. What it says is not that the user will stop. It would not get the benefit of Waqf till we decide.
What will happen then? What will happen? Where will the rent be paid?
But there is no, who pays rent to whom?
No. Suppose it's for rent, or it is being used. Suppose it is being used as a work property by
Yes, my lord.
by the Muslims. Or
My lord, use is not stopped.
no, but what does it mean? It will not be. The property will be treated.
It would not get benefit
Not
of the Waqf.
But why have that proviso then? Why have
Would
it?
not have the Waqf itself.
Because it's such serve.
My lord, if I can, my lord, humbly argue, my lord, rather than, my lord,
You want that answer?
the Lord, exchange may not assist your lordship correctly. Lord, the point is, if it is it's my lord, the position as a Waqf remains under suspension because the property being Waqf carries with it certain benefits under the trust, under the Waqf Act. So nobody says that usage will stop. It would stop to be Waqf property, and ultimately what would happen? 3. Please see, have a look at 3. Can we have a look at number 3?
Yes.
In case the designated officer determines the property to be a government property, he shall make necessary corrections in revenue record. These are revenue proceedings. But if still somebody wants that, no, I want to exercise my right of ownership by way of adverse possession, for example, he can file appropriate proceedings. But there are remedies under that.
There's a bar to a civil suit.
83, 36, 7 months.
Let's see.
3610. My lord, kindly allow me to go in my own.
Yes.
Well, let's not, my lord. I would request your lordship. That's what exactly was done. And that's why, my lord, I'm facing questions which possibly does not arise. Kindly, my lord, now have a look at the state government shall, on receipt of the, my lord, Justice Vishwanath, Subclause 4 at page 8. The state government shall, on receipt of the report of the designated officer, direct the board to make appropriate correction in the records. This is only for the purpose of correcting revenue records. If there is any other remedy available, it can be a writ remedy, it can be any other remedy, or remedy under section 83 of the tribunal, Waqf tribunal, it is available to any aggrieved party. Now, my lord, may kindly have a look at. My lord, kindly come to 83 now.
You go in your own way. Solicitor, 30, after 83, deal with 36(7)(a) and 36(10)
Yes.
and resolve that there is a small conundrum. Come back after 83.
Okay, can your lordships come to 83 first?
Yes.
Yes, but both deal with different situations. Therefore, my lord, the state government, my lord, first of all, the middle part is, my lord, the amendment made in 2013, which, my lord, Mr. Sibal missed to read, my lord, on a very important question, which I'll read, my lord, subsequently. The state government shall, by notification in the official gazette, constitute as many tribunals as it may think fit for the determination of any dispute, question, or other matter relating to a Waqf or Waqf property, eviction of a tenant, or determination of rights and obligations of the lessor and the lessee of such property under this act, and define the local limits of the jurisdiction of such tribunals, provided that any other tribunal may, my lord, your lordships may skip, any mutawalli person interested in a Waqf or any other person aggrieved by an order made under this act, please mark, my lord, or rules made thereunder may make an application within the time specified in this act, or where no such time has been specified within such time as may be prescribed to the tribunal for determination of any dispute, question, or other thing relating to the Waqf, provided that if there is no tribunal, we are not concerned. Now, my lord, subsection 4 is, my lord, the composition of the tribunal, my lord, which they have not disputed, so I'm not taking your lordship to that. My lord, it's a judicial body, my lord. It has a judge in it, former judge in it. And one person with the knowledge of Muslim law, please have a look at page 90, my lords. The composition. Judicial review is not taken away, my lord. Please have your lordships have 4, my lord, 83(4). Every tribunal shall consist of 3 members, one person who is or has been a district judge, who shall be the chairman, and one person who is or has been an officer equivalent to the rank in the rank of joint secretary to the state government member, one person having knowledge of Muslim law and jurisprudence member, provided that the tribunal established so and so, so and so. That's earlier tribunal to continue. So there is a judicial review. Every order passed under the Act are subject matter of challenge before this. Now, my lord, answering my lord Justice Vishwanathan's question, my lord, please come to lord page 47. My lord.
No, you read 83(9) also. Further appeal to High Court in office.
Yes, there is a full-fledged. I'm sorry, I'm grateful. I should have. 83(5), my lord. Please have a look at 83(5), my lord. First, the tribunal shall be deemed to be a civil court and shall have the same powers as may be exercised by a civil court under Code of Civil Procedure while trying a suit or executing a decree or order. My lord, then it will follow its own procedures. My lord, now, please have a look at, my lord, 9 was earlier sealed 9, which is now deleted. It has become more expansive, transparent, and subjected to judicial review. This decision was final, ultimately, earlier. Decision of the tribunal under subsection 9 in 2013 Act, amendment made in 2013 was final. This is deleted. No person shall lie, no appeal shall lie against any decision or order, whether interim or otherwise, given or made by the tribunal, provided that High Court may, my lord, it's kind of a revisional.
Mr. Mehta, I'm still not able to get my answer. Is Waqf user which is established and identified or declared earlier now declared?
Registered, yes.
Even if it is declared, accepted.
My lord, my position is, my lord, and I'll put it on affidavit also if needed. My lord, nothing prevented registered.
No, but then that will be undoing something which is established.
My lord, because registration was mandatory from 2025. And you ought to.
And how will you register? How will you register in case of Waqf user? Because there will be no person who will say, I have done this. Or no, but nobody will be able to come forward. There will be no registered document also.
I'll place on record lakhs of works by user are registered.
Now come to subsection 2.
Dr. Singhvi says 4 lakh work by users are registered.
No, he said 4 by out of 8.
Not registered, the remaining are registered. So there are registered.
Look, as far as work by users is concerned, it may be very difficult to register. Now there is ambiguity there. I agree. You may argue that work by user is also being misused. You have a point there. We're not saying that.
We'll based on the facts, statistics, logic.
1 minute. You may have a point. It's being misused also. But at the same time, there is genuine work by users also. You can't say that there is no genuine work by user either.
I am going to, my lord, argue, even to the extent that Waqf by its very nature is.
No, you will be wrong. I've gone through the judgments right from Privy Council of 25. There you are wrong. Work by user has been accepted.
I'm saying.
And to if you are going to denotify work by user properties, it's going to there's an issue.
My lord, we will be able to justify based on.
Just come to the proviso to subsection 2. It's completely contrary to Prithvi Court. Just read that proviso.
Completely contrary to
Prithvi Court. Just read that proviso.
Of 2,
the subsection 2.
Yes, my lord. This is, my lord, not a mandate.
1 minute, please.
I'll read and allow me to explain.
This deals with the question of separation of powers, and is it not contrary to Prithvi Court? Don't interrupt, please. Please, let them answer. You just read the proviso.
provided further that nothing in this act shall, notwithstanding any judgment, decree, or order of any court, apply to a trust by whatever name called, established before or after the commencement of this act, or statutorily regulated by any statutory provision pertaining to public charities by a Muslim for purpose of similar to a waqf. My lord, kindly allow me. What does it say? My lord, I am a Muslim. I don't want to be governed by waqf.
Wait, just listen to the question, then you answer. The legislature cannot declare a judgment, decree, or order of a court as void.
It's super. There is no decree.
What the legislature can do is, the courts pronounce and declare the law or pass a judgment based upon the law as it exists. So you can remove the basis of the law, but you cannot declare by any legislation.
Understood. I'm not.
You cannot declare by a legislation that this degree judgment will not be binding.
Can I answer? I bow down. There is no judgment, decree, or order. My lord, I do not know why these words have come. Ignore that part. Ignore that part. So this is what happens when you are lawyers and, my lord, those who are, anyway, my lord, I don't wish to use a word which might become a little controversial, but I'm, my lord, arguing a matter. It's not, my lord,
two more things now.
Only minute, my lord, what does this mean? Ignore, my lord, that part, judgment, order, or decree, my lord, ignore that part. What does it say? I am a Muslim. My lord, there are two waqf boards here before your lordship supporting this. There is, my lord, a large section of Muslims who do not wish to be governed by the Waqf board because of various things, my lord, which I'll place on record. Suppose a Muslim wants to do charity, it is not mandatory for him now to do only charity under the name of Waqf. He can create a public trust or a private trust. This is enabling provision.
So that there are positive points. My brother specifically pointed out there are positive points.
Yes.
There are issues which are concerning also with regard to past established Waqf user. Number one. Number two, how do you read as far as the section 9 is concerned?
Yes, my lord, kindly read it fully. Kindly read it fully, my lord. That's why I wanted your lordships to read it. Because Mr. Sibal, my lord, missed that part of it, my lord. My lord, page 19, my lord, your lordships would have it at page 19.
Yes.
My learned friend, my lord, used a very harsh language, complete usurpation by the central government. Now they will appoint. Your lordships would recollect. I do not know whether that was for your lordship's consideration or somewhere else. Now, my lord, kindly have a look at how, my lord, it existed.
Very comment to make.
Nine
should make such.
Mr. Sibal.
Anyway.
Right.
Mr. Sibal.
My difficulty is.
Doing it for your government. That's okay. I don't mind.
My lord, my difficulty is. This is not only for. I can't have, my lord,
We have conducted proceedings in of decorum.
Decorum. I'll not lose that decorum because this is the only forum I have. My lord, please have a look at section 9, which it existed in 1995. For the purpose of advising it on matters concerning the working of boards and the due administration of waqf, the central government may. It is not usurpation. It has always been the central government which has nominated this body. By notification in the official gazette, establish a council to be called Central Waqf Council. Now, my lord, in 2013, which Mr. Sibal missed, my lord, kindly have a look at the next page. They made the amendment again empowering the central government. Please have a look at the central government may, by notification in the official gazette, establish a council to be called the Central Waqf Council for the purpose of advising the central government, the state government, and the boards on the matter concerning working of boards and the due administration of waqf. This is only a consultative advisory body. It is not, my lord, administering the waqf itself. It gives a broader outline to the central government, how boards are to perform, etc., etc. But it has always been by the central government. My lord, unfortunately, this was not read, and it was argued that it is usurpation. Now, please come to, my lord, the composition, my lord, at page.
To slowly do the numerical count as you go on.
Yes, my lord. But, my lord, I would, my lord, at the outset say that ultimately we will argue, not today, that when there is a consultative body.
Mr. Tushar Mehta, are you arguing then that as far as Hindu endowment bodies are concerned, Hindu religious are concerned, you will allow minorities including Muslims, to be member of those councils and boards?
I'll answer that.
Please say that very openly.
I'll answer that. Look, kindly have a look at, let's numerically go. Let's numerically go. Please. Okay. Lord, kindly see 9(1)(a). Council referred to in subsection 1 shall